Okay, again, good afternoon, welcome everyone. Let me call the case for hearing. As I understand, this is cause number P-37665. This is in the estate of Ramiro Guerra. Let me have announcements for the record.
Good afternoon, Your Honor. Pam Alexander. I represent the decedent's spouse, Mary Guerra, and she is here present with me.
Your Honor, good afternoon. Luis Gutierrez here on behalf of one of the decedent's sons, Ramiro Guerra.
Okay, I believe what's pending, Ms. Alexander, is your application to appoint a successor. I'll hear you on your motion. You want to call a witness?
Yes, Your Honor. If I could just give the court a little bit of background. I know the court's very familiar with this case because it's been before you due to the
No, but I appreciate whatever you can tell me because it's been a while. So please feel free.
Okay, Judge. So, Your Honor, the decedent is my client's husband. And he had a will, and the court in 2016, his granddaughter was named independent executrix pursuant to the will. Many years passed, she never really did anything, so the court removed her. And there was an alternate executor, which was also a grandchild of the decedent. And he became executor earlier this year, and he also didn't do anything. So the court removed him on August 25th of this year. So right now the estate is, and there were no other alternates named in the will. Right now the estate is without an administrator or a personal representative. My client is asking to be named as administrator, dependent administrator. You know, there are other heirs. He had other children that are mentioned in the will. She would be, Your Honor, the most reasonable and obvious choice because, well, not only because she's the spouse, but the decedent had his life here with her, and all of the other relatives are like in Michigan. So they don't really have any knowledge of kind of what was going on with his life. I mean, they're definitely beneficiaries to his estate, but they just don't know anything about his situation here. So my client is seeking to be named administrator, Your Honor. And so that's our motion. That's what we're requesting. That, you know, obviously they were married, Your Honor, so there are assets that she has that, you know, have been sitting there because the previous two executors didn't do anything. There was even a vehicle that was lost, and me and her prior counsel told her you can't really do anything because it has to be them. A vehicle that was left to actually the alternate executor. So there have been a lot of things going on with the estate that she's kind of had her hands tied because she can't act. So we are requesting that she be named administrator, Your Honor.
Clarify the vehicle. I'll hear from you in a minute, Mr. The vehicle is gone. I'm sorry, you said something, but I didn't catch it. What?
Lost the truck.
No, I need to call the storage.
Right. What happened, Your Honor, is it was like a storage, and they stopped paying it, and the fees got like outrageous. And I told her she couldn't interfere. And so she thinks the storage, they may have, I guess, you know, gone through their procedures to foreclose on it, or however they do that. But, you know, so things like that have occurred that at that time there was an executor, and so she would try to make contact and all that, and they never did anything. So that's just an example of how like someone needs to be responsible here for the estate.
Okay, I'll need to hear evidence that she is qualified and evidence of the assets so I can set bond if I grant your application. But Mr. Gutierrez, I cut you off, or someone cut you off. I certainly want to give you an opportunity to say what you wanted to say.
Yeah, no worries, Your Honor. Thank you. I just wanted to make sure, because I filed an opposition on behalf of my client to the application earlier this morning. I had reached out to Ms. Alexander yesterday, just let her know that I'd be filing it. You know, it's true that, and certainly, I think we're all on the same page. Certainly my client, Mr. Ramiro Guerra, is on the same page as far as that things need to get done in this estate, and that this needs to move forward, and we need to move the ball. So with that, I certainly agree. But he has been sort of on the sidelines and hasn't had any. He wasn't named in the will, so he's in the same position as Ms. Guerra, in the sense that he hasn't had any participation here. However, I will say that from talking to him, talking to other members of the family, one of which I represent, she's the mother of children which are set to inherit another of the daughters' share, Yvonne Rondell. That is being worked out. Her will is up in Michigan, and it has been probated in Michigan, and that's getting worked out so that the minors are represented, and we can. But in the meantime, I wanted to point out that I've talked to her, and she also, of course, opposes this motion. One of the things that Ms. Alexander mentioned was this vehicle. I've been told, and I don't have, and I think that there was also in the court's file, Your Honor, at one point the previous executor, Ms. Georgianne, filed a letter or sent you an email, which is now part of the record, where she seems to indicate certain attempts to recoup that truck. In fact, that Miss Alexander's client went to the tow company, got personal belongings, and from it seemed like the previous executor had said, take the truck, get the truck so that we have it. But she didn't, Ms. Guerra didn't want to do that for whatever reason, but that didn't happen. We filed an opposition, Your Honor, based on the fact that we believe she may be unsuitable. And I don't know if Your Honor has had a chance to look at that. We also emailed it to you and Ms. Alexander. And so the grounds for unsuitability, Your Honor, is based on the fact that there is a note that was made payable to both her and the decedent. However, nobody has been collecting that note except for presumably Ms. Guerra. And one of the things that I had asked Ms. Alexander, and we discussed yesterday, and last time we were here, Your Honor, we were going to see about working things out. I'll let you know that for some reason I didn't get notice of her filing her application. That's not her fault. I don't know how that happened, where I didn't get notice until you sent out an order setting hearing in late October. And then I got my family and I got sick. I've been out for the last 2 weeks with COVID. I was taking care of my wife and kids, and then the last week myself sick. So I'm getting back into it. But anyway, we didn't have a chance to confer until yesterday. And one of the things that I wanted to see what we can work out is we may be able to, work out where we may withdraw our opposition. But I think my clients would like to know what assets of the estate she has. And I think we would need an accounting of that to make sure that there is no, that she is suitable, and that, and it may qualm or may satisfy our concerns, Your Honor. That note from what we know has been being paid, and there's also personal belongings that nothing has been distributed to the beneficiaries or to the executor of the estate. Personal belongings of the decedent, which the will also states goes in to beneficiaries other than his wife. So those are the concerns we have, Your Honor. We'd ask that, I think I'm hopeful that we can work something out. Again, I think everybody's on the same page as far as this moving forward. It's just a matter of getting over some trust issues that have developed throughout the years. And I'm hopeful that between Miss Alexander and myself, we can get something done.
Excuse me, Ms. Alexander, there are no. Your motion speaks to personal property that was not delivered. The only personal property bequest that I see is this truck, which we've already discussed. You're saying, and everything else kind of winds up on a residual clause with a fourth, which
Correct.
is, I mean, I don't know how you're going to divide a dining table, but that's kind of part of the problem with the state administration that works itself out towards the end. But there's not anything, am I correct? In my understanding, there's no other than the truck, no other specific personal property bequest that has not been fulfilled.
That is correct, Your Honor. I will point out, it's our client's belief that there was also stocks and bonds that we don't know anything about. And so that's
okay,
all.
but they would be part of the 25% distributions.
Correct.
Okay.
Yeah, I just wanted to inform the court that there may be, other than just, the refrigerator, that kind of stuff, furniture that, you hate to fight over. There may be other assets that may fall into that residuary clause.
Okay, so Ms. Alexander will have to elicit testimony from her client about her being qualified and willing to serve. And I would ask Ms. Alexander that you cover the amount of assets, because this will be covered by some sort of bond,
Yes.
which would be a corporate surety bond, Mr. Gutierrez, which may or may not, it may give your clients some solace that there will be at least some cognitive, something of value there in a bond to recover damages later on, where
Right.
now no one has any coverage about anything. And you'll be allowed to cross-examine, so you might get the answers that you need here today.
Okay, Your Honor.
On your,
If Your Honor is inclined to move forward, I mean, and I would ask, my client has asked me to ask if we can have a short continuance. If you wanted to move forward with the application, just so that we can develop some of these and get some more information prior to today's hearing and moving forward with an administration, so I can effectively also cross-examine Ms. Guerra again, and hopefully it doesn't even come to that. But I think if we can get information from her through Ms. Alexander prior to a hearing on her application, we may be able to come to an agreement and we can withdraw our opposition. And if not, I would at that point be a little bit more prepared to have to be able to follow up on cross-examination questions, Your Honor, based off of the information that they provide, and if she's been receiving payments, personal property, what has gone on. I mean, I think that's something that needs to be developed a little bit more. And we'd ask if we can have a short continuance so that they can provide that information, and then we can evaluate if it's even necessary for me to cross-examine.
Ms. Alexander, response on the request for a continuance.
Your Honor, I would be opposed. This has been pending for so long. I ask that we just move forward. And I think some of the things that Mr. Gutierrez is concerned about, I can get my client to testify on right now, especially like the part about a note and her collecting on it. She can testify to that. That way the court can be satisfied that she didn't, run off with all the money or anything like that. So I'd like to be given the opportunity for at least the court to hear her. And then if the court feels like more information is needed, then, obviously that's the court's.
I'm inclined to do that, Mr. Gutierrez. I do want to hear the testimony, and I want you to have the benefit of that testimony and at least exhaust the possibility that you all may agree, decide to withdraw your opposition. Not that you have to, but at least I won't grant it today, and I won't take any action for, say, a week. What I want to do want to inform the parties is that I'm kind of on a timetable here, is that by the end of December, I'm gonna withdraw from all these cases that I've been handling. Every December we have to resubmit affidavits and oaths that qualify us to serve, and I just don't intend to do it anymore. So I wanted to have this hearing because of the history of the case, and at least have a chance to have an administrator with authority to proceed beyond December 31. So I want to encourage you to reach some sort of agreement if you can. If not, on December 31, I'm essentially declining the assignments originally made on all the cases. You're not being picked on or anything. I'm just, I've done this for 4 years and I really want to be retired, not just retired.
I think that's completely understandable.
So that's really what's going on in that regard. So I've got another hearing at 2:30. Let's see if we can get the evidence, and I'll give you a chance to cross-examine about the questions your client has, Mr. Gutierrez, and based on what what you hear, then I'll either hear that you all have agreed or withdrawn your opposition, or I won't. If not, I'll either make a ruling before December 31 or decline any further participation in the case, depending on my comfort level. Okay, Ms. Alexander, you call your first witness.
Thank you, Your Honor. I would call Mary Guerra.
All right, Ms. Guerra, I'll ask you to raise your right hand, please, ma'am. Will you swear or affirm testimony you're about to give will be the truth?
Yes.
Go ahead, Ms. Alexander.
Thank you. Ma'am, please state your name and address for the record.
Yes, my name is Maria D. Guerra, and I live at 3824 North Sherbach Road in Mission, Texas, 78574.
Okay, ma'am, and you are the widow of Ramiro Guerra, is that correct?
Yes.
Which is the case before the court today, is that right?
Yes.
Okay, and is it correct that in October of 2006, his will was probated and Georgiana Gary, his granddaughter, was named as executrix?
Yes.
And subsequently, this honorable court removed Ms. Gary, and the successor executor, Blaine Morales, was appointed as independent executor. Is that correct?
That is correct.
Okay. And then in August of this year, 2022, this honorable court removed Mr. Morales as well. Is that correct? So at this time, there is no executor or administrator on this estate. Is that correct?
Yes.
And you're now asking the court to be named as a dependent administrator of your husband's estate. Okay.
Yeah, that is correct.
Okay. Now, I have to ask you, Ms. Guerra, you and your husband were married and together at the time of his death. Is that correct? There was no separation or anything of that nature.
I spent my time taking care of him 110%. I quit working to take care of him.
Okay. Now you have heard that there are some concerns from Mr. Gutierrez's client, which is your husband's son. You heard that, is that correct?
Yes.
Okay. Now, one of those concerns is that there was a property that you and your husband had sold in Mission, Texas, some 6 acres.
Yes.
Okay. Now that property, there was a note in which you and your husband were receiving payments. Is that correct?
That is correct.
Now, what was the value of that note?
It was about 250,000.
Okay. And now obviously your husband passed away, let's see, about 6 years ago now.
Yeah, we sold it in 2015 and he passed away in 2016.
Okay. Now, have you been collecting the payments on that note?
Yes, I have.
Okay.
They've been paying me.
Okay. And what are you doing with those payments?
Oh, all that money is there. I've been paying all the taxes for all these years for all the properties.
Right. But that money,
And that money, I have never touched it. Everything is there. And I have already given Georgie at that time when the probate was recorded. I gave her, half of that balance that we had that we were collecting from that note from those 6 acres. And there was about maybe like 26 or 28. So I gave her half since they were already here. I didn't know any better at that time, my attorney was Joanne Garcia. And she told me that I shouldn't have done that, but I didn't know any better. I thought to myself, since they were already here, I gave her half, his half of my husband's half to them.
Because she was the executor named in the will?
Yes.
Okay.
Yeah, so that she can distribute to the other too, and her
Okay.
and herself.
Okay.
Mhm.
But since that stopped, you have continued to keep those monies in an
Oh, yes.
account and they're
Yes,
there.
I don't touch that money for anything because I always knew, because of my husband's half, we're gonna distribute 25% each, so that money is there and it has never been touched and it's there.
Okay, now there was some concerns that you perhaps didn't cooperate with Georgina. Is that
No.
accurate?
No, that is not correct because I always told her, since they're over there, I'm the only one that is here. And I always told her and Blaine also, I said, you guys, if you need anything, I'm here. We can work together, whatever you need, just let me know. I'll get it for you. But they stopped talking. I called them. They never answered, neither Georgie nor Blaine. So I don't know what is going on here. And I'm already like, now that everything that has been going on, and I was the one actually who told my husband that I didn't want to be the executive, to be in charge. I told him, let somebody else take care of it because it was our second marriage and I didn't want so now, and I didn't know anything about the court or anything like that. Like I said, and I gave Georgie half of that money that we had collected. But now with everything that has been going on, now I'm prepared. I think that I can do whatever needs to be done.
Okay,
Because and it's already gonna be 7 years and I'm gonna be needing the money because I'm the one who's been paying all the taxes for all the properties. They don't help me for anything. I had told Blaine when he wanted to be the executor, I told him, Blaine, you know that I've been paying for all the taxes. I've been Waco and the ones here. And he said, well, Mary, why are you paying those taxes? I said, why? Because he was my husband. And that was his pride and joy, that property up in Waco, and I didn't want to let it go for him. And I'm here to protect my husband because actually he didn't even trust his own son. I mean,
I know.
Oh
Hold on.
my God.
Now, there's also some concern about his personal property. Now, is it correct that that you were advised that was something that the executor needed to handle?
Which
The division of your husband's property, his personal property.
oh, like what's in the house and all that?
Yeah,
Yeah,
paintings.
well, there were that trailer, those trailers, the ones those big ones. But it was like a homemade and there's the lawn tractors. I don't know if Rick is talking about a John Deere lawn tractor that is still there. We never fix it up. I don't know if he's or the sofas, or I told him when they were here because we have two. I say if you want to take one, go ahead.
But you did your husband have any other significant personal property other than like his personal effects, clothes, things like that?
Well, the clothes are still there. And at that time when Yvonne was, she was still alive, may she rest in peace. But I had told her, all the shirts and everything, the nice shirts that they can wear up there, like Yvonne's husband and Rick and the other grandson. And they just told me to hold, and I still have everything,
You still have
everything is
everything.
there, yes.
Okay.
Because I've been waiting for all this to be over and done with. I mean, I'm not.
Okay, now, do you have any felonies?
Like
Criminal,
No.
criminal felonies?
no, thank God,
Okay.
no,
Okay.
but the only.
Oh, go ahead.
No, about the personal things, I'm thinking that Georgia at that time, when she was the executor, she took out the safety deposit box. And in that safety deposit box, there was some money in there, and there were coins, gold coins and silver coins that my husband had purchased when we were married. And there's one thing that I think that Rick wanted to verify that, and we found it when they were here, when he purchased them and everything. We were already married. We got married in 1999.
But you said that Georgina
And she
took
took out that safety deposit box that she has up in Michigan, and I don't know what she has done with it. And I know that Mr. Talbot, who made the will, he says, Mary, half of that belongs to you.
right.
But
Okay.
she took it, and I don't know what else, to.
Okay.
Mhm.
Now, as far as the real property, obviously the 6 acres were sold. Your husband owned a property, well, you all owned a property in Waco, Texas, is that correct?
Yes, and that belonged to him.
That was
Yes,
prior-
That was his, yeah.
Okay, do you know the value of that property?
No, not really, because, you know, at that time, you know, we had seen actually he had called a realtor, and this lady had told him that it was about $3,000 an acre. But he in his mind, he always thought that it was more than that.
Okay,
But that's been way back then, you know, when he was still alive, and I don't know about now.
okay.
How many
and-
acres, man? How many acres?
Less than 60, it's about 61, 62 acres, just empty land. It's in Eddy, Texas, by Eddy, not Waco, but we always call it Waco.
Okay.
Yeah.
Now you have your home on, well, not your home, 908 Bryce.
Yes, we purchased that together, just like the 6 acres that I put my half and my husband put his half. So those 2 properties belong, half is mine and half is his.
Okay, but the value of the 908 Bryce, we had it listed at about 46,000.
How
Is
much
that
we
accurate?
paid for it, yes.
Okay, and the 900 Bryce is
Oh,
about
that one, we
50,000.
also bought it together. I put my half and he put his half. And at that time, way back in 2001, it was we bought it for about maybe 32.
Okay,
Mhm.
we
And
had
then
estimated that maybe now it's about 50.
Yeah.
Okay, now your home, where you live in Mission,
Mhm.
estimated at about 250,000.
Yeah, well, that's what we think, but my husband always said that, you know, since we had been fixing it up and, you know,
It
we
might be worth
remodeled
more.
it and all that, so he always thought that maybe about that much, but I don't know. To tell you the
Okay.
truth. Mhm.
Other than those 4 properties, the 2 on Bryce, the 1 in Waco, and then the one where you live now, did you and your husband own any other real property, meaning land, houses, things like that?
No,
Okay,
no, when he came to live here in the valley, that's when we started, you know.
Buying
When he
things.
came here to the valley, he only had his those acres up in Eddy, Texas, by
Okay.
Waco. That's what he had. And then when we got married and everything, we started, both of us, you know, investing both my money and his money into those little properties that we have.
okay. Did your husband have any like stocks or bonds that you know of?
No, at that time, he had one with I think it was a Wells Fargo, but like a year before, he had already like closed that account, and I had put in there about 8,000 myself with his account, and so that's why he had left what I had put in there. So that was mine.
Okay, you're saying
Excuse
that,
me, Ms. Alexander, I had set the other matter for 2:30. I just want to let him know that I was gonna try to do it, but I can't do it and listen. And let me just call one of the lawyers in the other case to tell him stand by. Let me just get a phone number here.
okay.
Stand by.
Yes, Ron.
unavailable to take your call at this time. Please leave a detailed message and we will return your call the next business day. Thank you. Please record your voice message at the tone. When you are finished, please hang up or touch pound for more options.
Hey, let me try somebody else. Yes, good afternoon. This is Judge Homer Garza. Howard Reiner has a setting with me at 2:30 on a Zoom hearing. I wonder if I could talk to him.
Okay, you said what is your name again?
Homer Garza, I'm the judge on the case.
Okay, 1 moment. Can I place in a brief hold?
Yes, that's fine.
Good afternoon, Judge.
Hey, Mr. Reiner, good afternoon. I'm trying to get a hold of the lawyers in your case. I know it's set for 2:30. I had another Zoom hearing at 2 and I'm still going on it. So I wanted to get a hold of somebody to let you know, don't go away, stand by. I'll be right with you. Could you get that? Thank you. I really appreciate that.
Okay, thank you, Judge.
Stand by.
Okay.
Stand by. I'll get back to you. Okay.
Okay,
All right, bye. Okay. Go ahead.
Okay, Ms. Guerra.
Yes,
So, okay, we talked about like disqualification, why an administrator would be disqualified, things like the felony, you know, you owed your husband money, any cases against you. Is there any reason why you would be disqualified from being an administrator?
I don't think so. No,
Okay.
I'm very fair. I mean, you know, I don't like to be, you know, like, I'm just going like I told Blaine when he was the executor, I said, well, Blaine, just follow instructions and whatever you need, I'll help you. I'm here. I'm the one that see who can do, you know, everything that you need. But then they stopped talking, they didn't answer. So yeah.
Okay, you were mentioning something about that your husband did have a Wells Fargo.
Oh, yes.
account.
Yeah, but he had closed that one about like a year before.
He passed?
Yeah, before he passed away, and I had put up like about 8,000 in there, or 6 or 8,000. Yeah, I think it was about 8,000 or so. So that's why he left there, because you know that money belonged to me, so that's why he left that to me. But that was it. But he had closed all.
He didn't have any other investment accounts, you know, stocks, bonds, anything other than that safety deposit box you're talking about?
Yes.
Did he have any other types of accounts?
Okay, there was one that he had about 23 with a credit union.
23,000?
Yes.
Okay.
And then at that time, well, Georgie wanted to withdraw it at that time, you know, when she was here. And there at the credit union, they didn't want to give it because I had signed the card too, you know, my name was there. So it was like for both, you know, for both of us.
Okay.
That's the only thing that I can think of.
Okay.
Now in the truck, like, you know, I wanted to have taken it out, but I had talked at that time, it was Joanne, you know, Joanne Garcia, and she told me like not to get involved because that I made. So I stopped, you know, because, you know, that truck, you know, it could have been stayed there at the house, you know, I wanted to just go pick up and just have it there. But I guess they were afraid that I was gonna drive it or something, or, you know.
So basically you wanted it at the house because it wouldn't be incurring storage costs.
Exactly.
Okay.
Mhm.
I believe that's all the testimony I have regarding the assets and the property. I don't know if the court needs any more clarity. I can certainly ask, but I believe that's all there is.
Mr. Gutierrez, you can cross.
Thank you, Your Honor. Ms. Guerra, good afternoon.
Good afternoon, Mr. Gutierrez.
You mentioned, well, you realize you're under oath. And in fact, we did put, you are under oath. You recognize that all your answers have to be truthful. You mentioned a Wells Fargo account.
Yes,
I'm a little confused. You mentioned it was closed, but then you said it was left to you. So was that Wells Fargo account closed?
yes, but that money that, it was about 8,000, which I had put it because he wanted me, like, if I wanted to invest, so I told him that, that I would like to, put, so I gave him, I think we have had it for about maybe a year, 2 years together with that money that I gave him. Maybe it was about 6,000 or so. And then at the end, well, what I had put in there, that's how much I had, with that money that I had put in there. So that it belonged to me. And at that time it was with Alexis Villarreal was
Okay. Let me be.
yeah, but Alexis Villarreal, the financial advisor, knows about that. So
Okay, but on his death, did he still have was there still a Wells Fargo account?
he was under my name because at that time when he withdraw all his money, they left it under my name.
Okay, and that would have been
I'm sorry.
and that would have been around what year?
Well, it was around maybe 2015 or so.
Okay, and did he have any other personal bank accounts?
No, well, and the checking account at that time when Georgiana was here, we went to the bank, and there was about like 30,000, and she took the bank gave her half, and they gave me the other half to me.
Okay, and earlier you mentioned, I guess I don't know if I heard it. What's your address, Ms. Guerra? Where do you live?
I live in Mission, 3824 North Sherbach Road in
Okay.
Mission, Texas.
Okay. Have you lived there? How have you lived there continuously since your husband's death?
Yes.
Okay. You haven't lived.
I stayed there. I thought that I had to move out because Rick, I think he wanted the house or something. And I was already getting ready to hire one of those trucks to move all the furniture with the appliances because I thought that I needed to move out because I thought that Rick was gonna stay with the house. And then, when I went, they recommended me to go see Joanne Garcia. And so when I went and I took her the will, she was reading my rights and she told me, no, Mary, you don't have to move out.
Okay, thank you, Ms. Guerra. And so it's your testimony today that you have not moved out and never moved out of the Schubach property?
No, I've always stayed there.
Did you ever reside in the other two properties, 900 Bryce or 908 Bryce?
Yes, we did. My husband and I lived there for about 2 years. And then after 2 years, we decided to come back to Sherbach, on Sherbach Road, where I live right now, because, and we were renting this other house, but then he decided that he didn't want to live there over here because it was too small and this and that. So my husband wanted to come back, so we came back.
And Ms. Guerra, you mentioned, and Ms. Alexander mentioned a property in Waco. Do you recall that?
Oh, yes, sir. Mhm.
How, you said you've been paying the taxes?
Yes.
How much have you been paying in taxes?
Well, it's been
A
since
year.
2016, since 2016, I paid them. And then when, Georgiana was receiving.
I'm sorry, Your Honor, I'm going to object to non-responsive. I just want to know, and maybe I can rephrase the question, Ms. Guerra, how much a year approximately are you paying in taxes for just the Waco property?
For just the Waco, well, it's been about since 2017, since 2016, I paid them. And up till now, I'm gonna have to pay them again. So 2016, 17, 18, 19, 21, 22. It's gonna be 6 years. And I say about, because it's just empty land, it's not as much as it is here in the valley, but it's about, I want to say maybe 6,000 or 7,000, I want to say. Or more or less. I have not added up or up till now, but I have statements.
Okay. Ms. Guerra, what did Mr. Guerra ever tell you how much he thought the property was worth?
Yes.
And
One
what did he think it was worth?
Yes, the last time that we were there in Waco, he called a realtor, this lady, and he talked to this lady, and he was telling her about, these acres there in Eddy, Texas, and she told him that it would, that they were running about $3,000, and he thought that it was, way too low for him.
So again, I'll rephrase the question. How much did your husband think the property was worth?
Oh, well, the thing was that there was a survey from the Austin area, because he sold a little piece of property to Texas.
Your Honor, I know you're, and I'm going to object again. I'm sorry, Ms. Guerra, I hate to keep on interrupting you, but I know the judge has his hearing, and I don't want to have this any longer. I'm asking a very specific question.
Okay.
How much did your...
Yes, there's a survey that they did, and it said that it was about less than 700. That it was about 689,000. That's the survey.
And Ms. Guerra, and when you say a survey, do you mean an appraisal?
An appraisal, I'm sorry. Yes, an appraisal. Yes.
Thank you.
Mhm.
And do you have you seen an inventory that was filed by the previous executor?
Oh, well, Georgie, oh, okay, well, yes.
Did you?
You've been so long.
And that property is listed as a value of $1 million.
Yeah, because I was going to by the not the survey, but the appraisal. But
Okay.
for maybe by now, then maybe thinking that it has gone up,
Okay.
out of the 689. That's what I think.
And so your earlier testimony about it being 3,000 an acre sounds like that's is very, very low. Is that right?
At that time, yes.
Okay. Ms. Guerra, and you acknowledge that that Waco property is your husband's separate property, is that correct?
Yes, because when they got a divorce, he stayed with that property.
Okay. And going back to the notes that you have been collecting, how much have you collected in total?
Right now, there's about 159,000.
And that's in the account right now?
Yes, they were paying me because I also am the owner of that property.
Correct. And so that 159,000, that is sitting in a bank account right now.
Yes.
Okay. And half of that would be your husband's, his estates, is that correct?
Yes.
Okay. Has any money been removed or withdrawn from that account?
Well, from the beginning, when we first sold them, they gave us there was a little bit of they gave us about, I don't know, for the down payment about, it's been about maybe like 7,000 or 8,000, but since we had purchased it together, we got half of that money, each of us got half and half. And then when they were gonna start paying the notes, the payments, we opened a savings that it was gonna go to that account. We opened it with $50.
And so that account is at what bank?
With Bank of America.
Okay. And it was titled under you and your husband's name?
It was both, but then when my husband passed away, the bank told me to take the death certificate and they removed his name, so it only stay under my name. But they asked for it, you know.
And since after his death, you continue to deposit the amount of the note payment into that account?
Yes.
Okay.
Yes. Mhm.
And earlier, I think you testified about, or I just want to make sure we were talking about stocks and bonds. Are you aware of any stocks and bonds that he owned shortly before his death?
No, it was just that one that that I told you about, where he left that I had put in there about 6,000 or 8,000.
And did he have, I'm sorry, and did he have a safe at home?
No,
Okay.
he only had the safety deposit box at the credit union, which Georgie took out.
I'm just gonna finish going over my notes real quick just to make sure we don't miss anything. And so Ms. Guerra, you acknowledge that Ms. Yvonne's grandchildren, or rather her children, or her estate is a beneficiary of the estate?
Yes,
And you also recognize that Ramiro Ricardo Guerra is a beneficiary of the estate and will
Yes, of
receive his share, is that right?
yes, oh, yes.
Um,
Yes, we're all supposed to get the 25%. The four of us.
and Ms. Guerra, you mentioned earlier about paying taxes on all the properties. On some of these properties, you have a 50% interest, is that correct?
Yes,
So half of those payments that's your debt, not the estate's.
right. Yeah, because we're just at 908, and because the other one I'm paying for the 900, I'm paying for, but for the 908 and the.
I think, Your Honor, I think though that's all the questions I'd have. I'd reserve, for any future, in case we need to, or there's any follow-up, I'd like to have the opportunity to in case we need to file an additional brief in opposition or to, based on this testimony. But I would ask that the court take judicial notice and take into account the amount of assets, particularly about the warehouse. I know we're not at this point right now, but in the future, if it gets to that point, Your Honor, regarding the bond, I think it's important, the Waco property.
Yeah, I was thinking, what warehouse?
I'm thinking of another case that you trust me, you don't want to have anything to do with, but anyway.
But let me tell you what I'm proposed to do. I do want to ask your opinion, Mr. Gutierrez, on in the event I grant the application, what bond do you think would be fair? And Ms. Alexander, I'd like to ask you, what bond you think would be fair? I'm a little scatterbrained. I made as many notes as I could, but I'd like to get your individual opinions about the amount of bond that might be considered. And given the history of the case, I might even be willing to consider bond for real estate, which is not normally necessary, but we just have had so many delays. But I'll hear the opinion from each of you. Well, I'll tell you, Mr. Gutierrez, I won't make a decision until, if I'm gonna make a decision, it won't be before Friday, December 9th at 5 o'clock, to give you a chance to discuss this with your client and see if it can become an agreed order. If I don't hear from you by 5 o'clock, December 9th, I just assume that you stand by your objection. And I'll either make a ruling or not, depending on what. And by the way, you certainly are willing to, you're able to submit a supplemental brief if you like, to talk to me about the conflicts and from your point of view, and the fitness to serve. I think it's the correct phrase. I'm trying to look at my notes. Unsuitability. Can you give me an amount, Mr. Gutierrez, and then I'll see what Ms. Alexander says.
Your Honor, I'm a little like you, a little scatterbrained at this point. I was jotting notes myself as much as I could to come up with what that would look like. I mean, I think maybe what we can do is also if we could submit that to the court, or what I was also going to suggest, if you wanted to set us, but I know we're in December, and for a status or for a follow-up hearing in a couple of weeks, but I'll represent to the court that I'll be gone from the 9th to the 18th, so that maybe that's not as doable, but I'd be certainly available anytime after that. After the
Well, if you don't feel comfortable sharing an amount, I wanted to give you the opportunity. You can certainly
supplement.
Update. If you form an opinion based on your review, share it with me. I'm not going to make any decisions till Friday, December 9th. Ms. Alexander,
I'll do
you
that,
want to
Your
just have
Your
some time
Honor,
to think about it?
So the big, I guess, what appears could be the most valuable thing in the estate would be this Waco property. Even if we just like split it down the middle and say it's worth $500,000, that would be about, also considering the note amount, that would be about $1 million worth of property that belong to both of them. But other than the real property, there is almost nothing of value. And I don't want to say nothing of value, that's not the right term, but nothing of significant value. I mean, there's some old tractor that's still on the property. And then of course his personal effects. And then that old truck, Your Honor, that I think worth about $2,000 or so, if it's even still in the estate. So there's really no significant personal property to be concerned with. So that's I don't know if that gives the court any guidance.
What was the balance of the funds that have been safeguarded, that were the payments on the note receivable? What was the balance? I wrote it down, but I don't.
159, I believe, is what my client testified.
Well,
But Your Honor, I will let the court know that the gentleman that purchased that property is wanting to pay it off, but there has been no one to be able to sign off for the estate. But he actually represented by Mr. Aleman, and that attorney's been calling me, asking me if there's a representative yet, because he wants to finish paying it. But I'm looking right now at the Bank of America statement, Your Honor, and it is, well, it's as of October, but $159,872.
Okay.
And Your Honor, I'm not sure if you were also thinking about the balance as far as what's left to be paid. And now that you mentioned that, Ms. Alexander, about Mr. Aleman, I don't know how much is left on the note to be paid.
Right. Well, you sold it for $225, right?
Okay.
Oh, here we go.
So he paid that's when he paid the last payment, was in May of 20.
Okay, so the balance is about $82,000. That would be the balance of more or less. That's about the balance of.
And this clearly is a community asset. Is that it's half and half?
Yes, Your Honor. This was purchased during the marriage.
Mhm.
Okay. Okay. Well, whatever each side wants to share with me on a bond amount,
Yeah.
I'll stay open till I get your respective opinions by Friday.
I will submit that, Your Honor. I will note regarding splitting it, I would think the floor would at least have to be the appraised amount, the appraisal amount, which was 685,000, I think Ms. Guerra testified to. To me, that would be the absolute least I think that we would want to, or we should consider. But I will note that again, the inventory listed at $1 million, and it seems like the decedent thought it was worth that. So
See, that's the delicate part is real estate is not normally bondable because it can't go anywhere without a court order. So it's not like they're going to steal a CD or a savings account. But at the same time, it's a good motivator to get someone with authority. You've been advised that there's the balance of the note is on the table. If someone has authority to collect it.
right.
On the other side of that coin, I heard testimony that the first executor received monies, they split accounts, received monies. That money has never been accounted for. Nothing's ever been done about it. No accounting has been. You did say that she filed an inventory. That's beyond my recollection, Mr. Gutierrez. Is that actually?
And your honor, let me clarify. I guess what I should say, they filed an affidavit in lieu of, and they've provided an inventory to the beneficiaries. And I'm glad you brought that up, your honor. I have had access to an inventory, in fact, but I've seen two versions, one which lists the note and which I think may have been in response to an objection that Ms. Guerra had filed, where, you know, Mr. Talbot kind of didn't put things in the right order, or his client. What
is that inventory? That do you recall the amount of personal property and the total asset?
Yes, your honor. In fact, you know what? It's also filed as at least the initial one as Exhibit A to Ms. Guerra's motion to remove, and that is, let's see. It has miscellaneous personal property at 2,500, but again, it didn't list everything correctly. It has 1.5 million as in real property.
I mean, I don't know what the court thinks about like $200,000 bond.
Okay. I don't.
I mean, that would account for all of the, pretty much the vast majority of whatever would be collectible on that note. And I mean, the only thing listed as personal property is that truck. That's about $2,000, Your Honor.
Well, and one thing that I will mention, Your Honor, there was also, I think Ms. Guerra mentioned it, or somebody mentioned it, regarding gold, or at least maybe it was my client, but I think Ms. Guerra mentioned it, that in that safety deposit box there were, I don't remember if it was bullion or medallions or something, or it's gold that I think might have been surrendered to Georgianne, and so presumably whoever the new administrator of the estate is, if it is Ms. Guerra, I mean, they'll have to get that from Georgianne.
Well, and Your Honor, I think part of the issue when the court, I know Mr. Gutierrez wasn't involved at this time, but when the court appointed Mr. Morales, the court ordered Ms. Georgianne had to appear before this court, and the court ordered her to turn over all these things, and she never did at that time. So, I mean,
well, even the inventory didn't account for the distributions that Ms. Guerra testified to, where they split existing accounts at least one
Right.
place.
And that
$2,500, there's no way that it covers probably even those safety deposit things. So man, this got started bad from the beginning.
yeah, it's been awful, Judge.
yeah.
Okay, so you're offering 200,000, Ms. Alexander. I'll wait to see what you have to say, Mr. Gutierrez. Like I said, I'm not going to do anything till Friday at 5 o'clock if I do anything.
Okay. Understood,
Anything
Judge.
else?
Thank you.
No, Your Honor. If the court denies, I guess we would just have to come back with a new judge. Would that be right?
Yeah.
Okay.
At the end of December 31, that's the latest date that I can do it. I may do it earlier, is just send Judge Herman a letter telling him I've declined this appointment, this assignment. Which is what I've done in a couple other cases that had pending matters that came up that, I mean, I was just couldn't get settings.
Yeah, no, we'll try to work something out, Your Honor. It may be that, if we can get stipulations, maybe as part of that agreed order. And like you said, and I'm well aware, it's a dependent administration. So, but if we could just get for my clients, so that they feel more comfortable, certain stipulations, I think we may be able to work it out. But we'll talk with Ms. Alexander before the 9th.
Okay, this seems worthy of some really good lawyer attention. I mean, there's substantial assets, then there are, distributions that need to be made to the gentleman's beneficiaries. He was very clear in his will what he wanted to have happen.
That is
And
correct.
here we are, almost 7 years after his passing, and you're not going to be able to do much unless everybody's in agreement. I mean, imagine a title company. Imagine you all trying to get a title company issue a title policy. They're going to want everybody to sign off on it, even though you have an administrator.
And I proposed to Ms. Alexander that maybe a family settlement agreement certainly seems like it'd be ideal in this situation.
Yes, if they could come to that agreement, certainly. Okay, well, I've got to move on to the other one. Thank you all. Have a good day.
Thank you, Your Honor. Great seeing you.
Roland, you're gonna have to sign up on the other one. Okay, y'all have a good day.